Good afternoon. Welcome to this business law class, and hope you guys are enjoying the spring. I finally made it to springtime. Hopefully we can actually be outside and do it. But until that happens, um, let's just enjoy from across the window. I am. It's birds and flowers outside. It's all pretty cool. So, and as we went through last week, we use this contract, the consultant agreement, as the contract template. We'll continue to use this as a template to go over what we need to go over. Let's see. It's you can make a choice of what to include inside of a contract, because the contract is drafted by hopefully you. If not, you're reviewed by someone else. And drafting, the drafter, the writer, the developer, the drafter can decide to include certain things and not include certain things. So when you're reading a contract or when you receive an offer, and you have to know that these essential terms generally needs to be included contract to be effective and covers enough things for it to be valid. But you can certainly make a more of an argument why it shouldn't be valid. But just on the practical point, if certain things covered, then the contract is going to be open to interpretations, have things that might be confusing and ambiguous, and that's probably not what you want. So without further ado, that's a few things. I'm going to have 5 things that I'll talk about as essential terms of the contract. Depends on, there could be more, but at least for this purpose, I'm going to consider 5 things. So the first thing is effective day. So most contracts that sign, consumer contracts or any other kind of contract, many times we put a day after our signature to sign this, you sign it. Even on a lease, it says sign this and you sign it. And underneath it always have a date box. And you sign, we put a date on there, and the date you sign it is the date the contract become valid. However, you actually document and memorialize a contract that's either in the past. Quite frequently, a employment contract is in the future. So many people are presented with a contract on their first day of work, and then they sign it, and then that's the contract that governs. But on the other hand, you might be negotiating a start date, right? So your start date might actually be way down into the future. Your start date might be, for example, September 1st. But this is only April now, so you might actually sign a contract today for a stay of September 1st, and the September 1st day is the effective day. Many times when we write contracts, we don't even include the signing day, because the effective day should be clearly and put into the contract. So adding a signing day sometimes actually is counterproductive and make people argue that they didn't sign it when you say they signed it. So let me switch back over to the contract template. Here it states this consulting agreement, the agreement dated April 1st, 2020, and that's the effective day. So we have this agreement that clearly indicates that the effective day is 2020 April 1st. So in a date, it's simply who the party is. So here, Dafan, and I will sign this box, and then I'll put my name here, and I'll put my title here as self. If you're signing for a business, you will say president. But the date is not as relevant as the effective. And sometimes we start to pay me starting on April 1st, but we had a handshake agreement. We didn't write it out into contract, into paper form today, and we signed it today. If the signature date governs, that means we didn't have an agreement before today, like between today and April 1st. A well-written, lawyer-written contract should really start with a effective day and indicate effective day rather than a signing day. That's 1. And 2, the second essential terms, it happened to be term. What is a term, you might ask? So the term is a period of time, right? That's what the word means. It's a period of time. So is how long the contract is good for. So in general, we do, I might say The term of this contract is 1 year. It should have a term provision for termination herein after provided. That's very legalese and lawyer talk, but I'll explain in a second. The operative word here is this agreement shall commence on the effective date. It starts on the effective day and it ends 1 year from the effective date. So of course, as we just discussed, at any time in between those two dates, based on this term definition, is covered with company on April 2nd, 2021, or March 31st, 2020, which is before or after the indicated term, only covers that time. So anything happens within that time, then it's covered time-wise. Anything that happens outside of this period, then it's not covered. That's why it's important to understand term. And while we're talking about term, like a lease, if you lease by the month, then start of the next month, then the lease turns over and renew again. If you have a year-to-year lease, quite frequently it will renew. If it will renew at the expiration of the first term. So, but that's not automatic. Like contract law doesn't allow necessarily for automatic renew of contracts. If you don't put the renewal in the contract, then it's open to interpretation. It's quite fair for someone to say, well, because that's a very reasonable interpretation. That's why extended for subsequent terms upon the mutual agreement of the company and the consultant. We can agree to extend the term. We can also agree to the same contract because we can agree to the same payment, same length, same services. And then also here we say may, right? If you pay attention. So here it says may, it's possible not to be extended. And compare that to here with the initial term, it says this newer language here. It basically just says if the two of you decides to extend the contract, one piece of evidence. Maybe when we first talk, I suggest that I work for actively told me that I'm not a consultant anymore. This automatic renewed. So you don't want that situation to happen. So to avoid ambiguity, we just simply put in that the term may be extended, but only upon mutual agreement by both parties. So then, if anything happens after 1 year, if no mutual agreement, then we part ways. So this way is clean. Sorry, I think there's a little bit of internet lag here. Give me 1 second. Yeah, so I'll repeat that. So quite frequently when we work as write contract for service providers or product sellers, we put in a provision that a contract automatically renews, because if you are the party that receives something, you want people to keep buying it. You don't necessarily want people to stop buying something. If people forget to terminate, forget to tell you don't want to order Netflix, if you don't cancel by the 30 days, then you have to pay for the first month, because that automatically kicks in. So many service contracts that I work on, probably virtually 100% of all the service contracts I work on, have a automatic renew provision, because people want to keep selling their products. So watch out for and one thing to know when it comes to automatic renew is that auto renew usually works like this. A contract will auto renew unless you terminate by writing. So like a lease, a rental lease, if you want to renew or if you want to terminate, you have to provide a notice to your landlord. Normally that's how it works. If you don't provide notice, then you have to give yourself 30 days to notify the other party. So first 2020, 30 days ahead of time. But many times if you look at the contracts that you sign, like your cell phone contract, you might frequently get 90 days or even 120-day notice periods. That means you have to give. In rental leases the same. Some rental leases are 90 days, which means if you don't terminate your contract, or if you don't decide to renew 90 days ahead of time, you lose. What happens. Landlords frequently do this, by the way. If they're friendly to you, if they end up not wanting you as a tenant and you miss the 90 days, then they don't have to continue the lease. So look out for the written notice provision and how long you have to give notice. All right. The third thing is considering which we talked about in one of the videos, and compensation. So consideration compensation obviously is important because you have to know how much you're getting paid or how much you're paying for a service. If you don't put that into the contract, then it's open to interpretation. It's just not complete, because how can we consider a service or product contract to be complete if you don't have a price? So generally we put it in there. So as a consultant or as a labor contract, you don't want to go into work and provide a service and have a handshake agreement, and you think you're going to make X amount of dollars, and then when you finish the service and you try to send an invoice and they say, well, we didn't agree to pay you that amount, and that's really a big problem. Believe it or not, it happens quite often. So I go back to my contract template, and or this example, you see the service fees on the compensation. It's very clearly stated that the the consultant will get paid the monthly fee of $1,000. And we even, to be comprehensive, we even put in subject to the payment terms in this section. Again, if you don't put payment terms, like the payment conditions or how to make payment, then maybe you work for a month and you say, well, they're supposed to pay me $1,000, but then you don't see the $1,000 for 3 months. They just don't pay you. How do you, then you go to them and say, okay, where's my $1,000? And they said, well, we're operating on net 90, which means you send an invoice and they have 90 days to pay it. Or they might say, we have a net 180, which is 6 month payment. So you want to be upfront and be clear in the contract about how you're going to get paid and when you're going to get paid. So in this case, we says any fee payment shall be made monthly within 10 days of receiving an accurate invoice from consultant. So this is very clear. At the end of the month, I will send a invoice to the company, and within 10 days of me sending or giving the invoice, they have to pay me. So there's no dispute. But this is a fair arrangement, because if I drag my feet and don't send the invoices, then they don't have to pay me, because if I'm not fulfilling my part of the bargain, why should they have to pay me? So that's payment terms, and as well as the compensation should be clearly stated. So that's the third thing. And then the fourth thing I want to talk about is the scope of coverage. The scope of coverage basically sets the bounds of what this contract covers. What does that mean? That means certain things are going to fall within the contract or is governed by the contract, and certain things are not going to be in the contract. So for example, if I get hired as a consultant, do I need to clean the toilet? I mean, that sounds kind of stupid, but if my contract says the scope of my service is to do whatever the business asks me to do, even if I'm a lawyer or a business consultant, well, if my contract says I should do whatever I'm being told to do, then if they tell me to clean the toilet, I should go clean the toilet, right? I mean, they'll be overpaying me to clean the toilet, but at the end of the day, it's within my service, scope of my service. So when you sign these contracts, enter into contracts, you got to think about not just the norm and not just the usual, but what else could possibly cover. So if you look at my contract template here, and it says consulting services. So the contract retains the consultant. The consultant agrees to make himself available as a consultant to the company, blah, blah, blah. So that's very general. So if legal advice has to be regular and customary, not like special and exotic. So if you wouldn't have, if I'm working as a business consultant, I guess you should not send me to try to fight your traffic ticket, because that is not general business legal consulting advice. And further, I put as is reasonably requested by the company. And the reasonably requested, anything that says reasonable is sort of a magic word in the contract. That means it's open to interpretations. So when you put reasonably in there, that gives both parties the latitude to kind of be flexible a little bit. Because then if you were to say, well, fighting a traffic ticket for the owner is a general legal advice, and I said, It might, in your mind, it might be general legal advice, but it's not reasonable for you to request me to take care of personal business on the professional and company business contract. So that gives me the opportunity to say that's reasonable. On the other hand, if your consultant doesn't want to do anything, and you can also turn around and say, well, that should be reasonably within the scope. So this blur the lines a little bit, and it's a double-edged sword. If it's blurs the lines a little bit, then you give people the wiggle room to wiggle in or wiggle out, but also you get that benefit as well. So a lot of times you will see the word reasonably in contracts for that reason. So people get that wiggle room. So that's the scope. And if you really want to be specific, down here, see, I further, just to be very clear, I put on two bullet points of what the general business legal consulting services are as reasonably requested, which advise the company on routine business legal matters. And I say advise the company, not people in the company, or just advise anyone. I advise the company only. And also, advisement does not include actual legal representation of the company or formation of any agency relationship. That's more legal talk, but basically, I don't, under this contract, I do not represent the company. I give advice, but I don't represent the company. And you know why I put in there is because $1,000 a month isn't really a lot of money to actually represent someone in a deal or in court. So we frequently enter into another agreement to actually represent the company in court or in a deal. So this is only advice giving as a consultant. So the actual representation or acting as an agent of the company require a different contract. I could actually put another line in this second bullet and says any actual representation or formation of an agency relationship requires a separate agreement. That's actually the more prudent thing to do. I didn't do it here because I actually have a different agreement for this template with the client that I have here. So this is actually the add-on to the other agreement. But if this is a standalone agreement for a single client, and this is the first one to enter into, I probably would put that second language, the second sentence that says any actual representation or formation of agency relationship would require another agreement and additional fees. It's all about making fees. It's all termination just means ending the contract. So contract generally ends in two ways, right? It either expires or it gets terminated. And termination can happen either mutually or unilaterally. That means by one party. Not sure if I spelled that right on the board, but yeah. So either by two parties or one party. This is mutually, of course, it means both parties. Unilateral means one party. So what does that mean? That means that a contract, because there's a term governing the contract, when a term runs to its end, in this case, when it gets to April 1st, 2021, if we don't renew it, then the contract ends and it expires and it terminates by expiration. But anytime before April 1st, 2020, under this example, I have to, there's a possibility that a contract gets terminated or not completely fulfilled by either both parties or one of the parties. So without language in there, we can almost argue that, quite frequently we do argue that without a language to let one side or both sides terminate the contract cannot be terminated. The only way then to terminate the contract is to let it run through and let it expire. Of course, by law, both parties, so here's the mutually, both parties can always amend. Both parties can always amend the contract, which means change the contract in some way. So even if you have a contract with no expiration or with no termination clause, if we both agreed, we can just sit down and write down something to add to the contract, an amendment that says we both agree to terminate this contract before it expires, and both parties don't owe each other anything else. So let's say I work for 6 months, but we decide to part ways mutually and amorally, we just don't want to work with each other anymore for whatever reason, we can do a handshake, we write a piece of paper, and we both agree to terminate this contract early, and I don't need to provide any more services, and they don't owe me any money, and that will be a mutual by termination by mutual agreement. That's really easy to do. What happened? The hardest thing to do, I think, is when one party wants to terminate and the other party does not terminate. And then does one party have the power to terminate an agreement early if there is no provision to allow them to do so? And that is not very clear. So let's turn to the contract and see what the contract says. My contract here says the company discretion. That means they have again, that's to further reiterate that the company has the option and I do not have the option. The consultant does not have the option. And at any time for good cause shown. So the only protection I have here is that so they can at any time, the company at its own option can at any time terminate this contract, but they have to do it for good cause shown. So they have to show a good cause. A good cause is a legal term, again. That generally means that you have to have a good reason. And these good reasons are very complex. Sometimes we put the good reasons in the contract. Sometimes we don't put a good reason in the contract. And so, for example, if I stole money from the company, or if I was charged with a crime as embezzling, or if I'm not doing my job, then that's a good cause, right? But if the company simply have no money to pay me, or they don't want to pay me anymore, that is not good cause. So under common law, in the history of contract law, there's a set of things that are generally accepted as a good cause, and there's a set of things generally not accepted as a good cause. But many times we also put the contracts in them. In this case, this clause really doesn't favor me as a consultant. It favors the company, but in this case, I'm okay with that because I'm friendly to fight it anyway. If you don't want my service anymore, that's fine. As long as we paid up to the point that I got compensated for what I did, then we can part ways. So I don't usually hold people over if they don't want to use me as a consultant anymore. That's why this doesn't matter to me so much. But if you have a full-time job and you're relying, let's say you moved out to California for a new job, and you spend a whole bunch of money moving there, and you had hope that this job will be long-term because you made a lot of sacrifices, then you don't want a clause like this. You don't want them to be able to get rid of you anytime they want, but you have no recourse. So at least you should have the good cause spelled out what they are. So they can say that, well, you have to be convicted of crimes, or if you file for bankruptcy, or if you stop coming to work, then yes, we can fire you. But we'll terminate the contract. But I think a lot of contracts have a moral clause, which is really a flexible catch-all, which says if you do anything that damages the company's reputation, or if you do anything they don't like really, then they can terminate the contract, and that gets fought over a lot in courts. I don't generally like those clauses on this side of the table, but if I ran a company, or if I was helping a company draft an agreement, I would absolutely put in there. So let's say if you are a consultant for the company, then something happens, you're not happy, so you go on Facebook and you're like, well, this company is cheating everybody out of their money, or this company is not being fair to its customers, which may or may not be true. But when you damage the reputation of a company, they should have a recourse to not work with you anymore instead of being locked into a contract. So that's why frequently we have these moral clauses in there. Even pro athletes have these moral clauses in. So if you do something really bad, you get arrested, or you get charged with a crime, they can then void your contract. That's exactly the teams and the league has the power to terminate your contract if you do something wrong, and then that falls into the good cause. So if you don't put anything down as a good cause, then it's based on what customarily consider as a good cause. But if you do put in there, then the employer has or the person, the side with the money, with the leverage, can put a lot of stuff in there that you might not even consider to be good cause. And one of the one of the good clauses in pro athlete contract is that if you play any extreme sports, like if you ride a motorcycle, if you ride a dirt bike, or if you go skydiving, those are actually good cause for them to terminate the contract and not pay you, even if you don't get hurt. Famously, I think one of the quarterbacks in the NFL actually lied about how they got hurt because they want to avoid having their contract voided based on that good cause, but they were hurt and doing something that they shouldn't be doing. So anyway, so that's termination. So these are the 5 things. Let me go back to my other. So these are the 5 things that are essential. We have effective day and term, which includes possibly how to renew the renewal procedure. We have consideration and compensation that should definitely be spelled out. The scope of coverage, and the more comprehensive, the better. And then a termination clause. So these things are absolutely necessary and essential in every contract. And without them, you run the risk of being having either an track or a contract that doesn't have enough terms and doesn't protect either party in. So it that on the forum, and I will respond in time. And I plan have another session about another set of terms, but I'm not going to put it into this session. So I do another session with another set of terms, and then we have another topic when it comes to contract. And then we will be done with the contract section. So does anyone have any questions? I understand that my internet might not be doing very well in this session, so if there's a little bit of lag or buffering, I apologize. You can always watch the live replay on this. It seems to be okay now, but I realized earlier it might be some issues. Let me ask, does anyone have any questions? I can always address it next time too if you guys have any questions. All right, while I'm waiting to see if anyone have questions, I hope you guys all are enjoying this one great spring weather, and I sincerely hope that we can all get out and go back to normal soon. But until then, you guys take care of yourself, and I will see you all next time. And I don't see any questions. So I will end it here, and hopefully you guys learn a little bit more about contracts, and let me know if you have questions. Like I said, add to the comments or the forum, or talk about the next session. All right. Well, enjoy your day and enjoy the rest of the spring weather. All right. Bye-bye now.